MedPay, health insurance, or a letter of protection. Which one should you actually use to pay for treatment after an Arizona car crash or a slip and fall? I'm going to give you the honest answer most personal injury lawyers will not give you, because the wrong choice here can cost you thousands of dollars at settlement. I'm Garrick, AV-rated Phoenix personal injury lawyer, owner of GAMESQ PLC, located in Maryville area of Phoenix. I don't refer my clients to chiropractic mills. I don't push letters of protection which my clients don't need, when my clients don't need. My job is to protect your net recovery, the money you actually take home. Here's the plan. I'm going to break it down, all three options. I'm going to explain when each one helps you, when each one hurts you, and tell you when I tell every one of my own clients. Let me start with MedPay. MedPay is medical payments coverage on your own auto policy. It pays your medical bills after a crash, regardless of fault. Most MedPay policies do not have a right of reimbursement in Arizona. That means the money is yours to use, and you usually don't get clawed back at settlement. If you have MedPay, use it. It is one of the cleanest tools in your toolbox. Next is health insurance. Health insurance is almost always the smartest way to pay for treatment. And this includes access, okay? Let me tell you why. Because health insurance pays your providers at a negotiated rate, pennies on the dollar, compared to the full billed amount. At settlement, you can often negotiate with the health insurance lien down even further. That means more money in your pocket. Yes, there are rules. ERISA plans, Medicare, Access, each have their own right of reimbursement. Oh, a real lawyer knows how to handle it. But the idea that you should skip health insurance and treat on lien is usually wrong. And it is often benefits the clinic or the lawyer more than it benefits you. Now, the letter of protection, or a lien. A letter of protection, or LOP, is a promise from your lawyer to a medical provider that the provider will get paid out of your settlement. The provider treats you now, they get paid later at full billed rates. Here's the problem. Those full billed rates are often 3, 4, even 5 times higher than what your health insurance would have paid. The bill comes straight out of your settlement, off the top, before you see a dollar. LOPs have a place. If you have no health insurance, no MedPay, and you genuinely can't access care, an LOP can be the difference between treatment and no treatment. But an LOP should be your last resort, not the default. So here's what I tell my own clients. Use MedPay first, run everything through your health insurance second, and use a letter of protection only when there is no other option. That order usually protects your health and your net recovery. If a lawyer is pushing you towards lien-based treatment before even looking at your MedPay and health insurance, you're allowed to ask why, and you're allowed to get a second opinion. And if you want a second opinion, visit GAMESQlaw.com or call me at 623-233-4416. This is just general information, no legal advice for your specific case, but you deserve to understand how this decision moves money into your pocket or out of it. That is why I never send my clients for lien-based care unless they don't have any other option. At GAMESQ, it is your injuries, our fight, your way.